we'll get started, since we're just past the noon hour. I'm so pleased to introduce Hiroshi Motomura. Hiroshi and I met this time last year at an immigration law professors conference in Irvine. Hiroshi is the Susan Westerberg Prager Professor of Law at the University of California, Los Angeles School of Law, where he teaches immigration law, immigrants' rights, and civil procedure. Hiroshi is almost certainly the most prominent immigration law professor in the academy. He's written numerous books, including Americans in Waiting, The Lost Story of Immigration and Citizenship in the United States. That book won a number of prominent awards and was chosen by the State Department for its suggested reading list for Foreign Service officers. I have a friend in the Foreign Service who has confirmed that that is still on the list. Hiroshi has also co-authored 2 immigration-related case books, both of which I actually use in my immigration law class. Hiroshi's scholarship has appeared in numerous law journals, including the Columbia Law Review, the Cornell Law Review, the Duke Law Journal, the University of Chicago Law Review, the Stanford Law Review, and the Georgetown Immigration Law Journal, among many others. In addition to his scholarship, Hiroshi has testified before Congress, served as a co-counsel or a volunteer consultant in numerous litigated cases in federal court, and he's been a member of the American Bar Association's Commission on Immigration. Before joining the faculty at UCLA Law in 2008, he was a distinguished professor of law at the University of North Carolina in Chapel Hill. And before that, he was the Nicholas Doman Professor of International Law at the University of Colorado Boulder. He's also served as a visiting professor at the University of Michigan's Law School and at a prominent university in Japan. He's won numerous teaching awards, and most recently was one of just 26 law professors nationwide profiled in the book What the Best Law Teachers Do, which was our book for our book club last year. Hiroshi went to college at Yale, and he received his law degree from the University of California at Berkeley. And he is here today to talk about his most recent book, Immigration Outside the Law, and we are so delighted to have you here. Please welcome Hiroshi Motomura.
Thanks, Colin, and it's really great to be here. I don't know how many basketball fans are here, but I figured this is a historic weekend, and I realized, well, when Jerry and Grant went in the corner and tried to take that three-point shot last week, I was thinking, okay, if this goes in, we're going to face a much more dour crowd next week, but he didn't, so I'm here. And you guys are all upbeat. So, as Colin said, I have this book out, Immigration Outside the Law, and I thought it's best for me to talk about that today, partly because it's fresh in my mind, and partly because the book has pretty much every thought I've had in the last 8 years in it, so it's really hard for me to talk about anything else at this point. But it's a complicated book in a lot of ways, and it's full of a lot of arguments, and I have to say that much of the point of the book is to try to mosaic many of the things that people think about and talk about when they think about unauthorized migration. So what I thought I would do is to give you a structure, tell you where the book came from, structure of the book. I know you've had access to parts of the book, and so I don't want to repeat things that you've already read. So from that perspective, you can stop me if I get too much into repetition. But I want to give you a sense of the structure of the book and where it came from. And then feel free to ask questions as we go, because I'd welcome having more of a conversation about not just the book, but also about the issue in general, because much of the purpose of the book is to try to address many different issues. Much of my own purpose was to look at a bunch of issues that I think a lot of people have written about in isolation. And I thought about it in isolation, but then try to figure out how do all these things connect with each other, and how does what's the historical connection between Mexican labor migration and current policy on temporary workers, or what does birthright and the citizenship under the 14th Amendment have to do with what's going on in Arizona and California? So what I'm going to let me just start by just telling you where the book came from, and that's not in the materials you said that you had access to, but I did this book a few years back. I guess it's about 8 years ago. I'm glad to hear it's actually still on the reading list. I know it's on the reading list. I thought maybe it's fallen off, but I guess it's still on. Okay, so this book has to do with the relationship between immigrants and citizens, and in particular, how historically this country has treated immigrants and thought of them in various sorts of ways. And the fundamental thing about the book is this book, is that it confronts a dilemma that I think is inherent in immigration law or in citizenship law, and that some people are citizens and some people are not. It's inherently unequal from that perspective if you have any kind of order. And at the same time, if we believe we're a country committed to equality, we have to deal with how we reconcile equality with the citizen non-citizen line. And so that's this question: how do you deal with equality for non-citizens? And the way I think about it in this book is to think about the way that we manage the relationship between immigrants and citizens, that it's not immediate equality, but the way we give access to equality that really matters. And that's why the whole point of the book is from immigrants to citizens. And I explain this now really because this book is very much a companion of the current book, that the current book grew out of this particular book. And so the only other thing I'll say about the argument in this book is that it tries to explain three ways that historically this country has thought about claims of justice, or trying to figure out exactly what kinds of claims immigrants might have to becoming full members of society. And I made up these terms, which are almost sort of woodenly academic, but I think they're descriptive, at least loosely so. The first one is the idea of immigration as contract, that a lot of times we say immigrants promise not to go on welfare, or immigrants when they come here, we infer a promise that they're not going to commit crimes. So that would be one way of thinking about it. But then on the other hand, sometimes the arguments for legalization in this country, legalization to formal immigration status, are based on the idea that, well, they might have broken the contract by coming here illegally, but they have ties in this country, they have a stake in this country, and so that's this idea of immigration as affiliation. And then the third is the idea that we treat immigrants really presumptively as citizens, that it's not, so you can think of immigration as contract as an equality that is, as terms of the original immigration promise, I guess you could say. Immigration as affiliation is kind of earned equality. And immigration as transition is kind of presumed equality, that we think about immigrants and we treat them from the day they get here, sort of not so much using citizenship as a merit badge for having become an American, but rather using citizenship as a way to help someone become an American, more as a vehicle. So there's a lot more in this book than that, but this is, the reason I mention this is because much of the criticism that I got, and I really made self-critical comments about the book, is that there's nothing in this book, or not much in this book, about unauthorized migration. And I really had to develop in my own mind this way of thinking about how we think about immigrants historically to get to this book, which we cover in this book. And so this book really raises this question: are unauthorized migrants, in some sense, Americans in waiting? And the title of Americans in Waiting is a term that is really intended to capture this idea of immigration as transition. I noticed that about a month ago, the White House blog referred to unauthorized migrants as Americans in waiting, and then President Obama got a lot of flack for this. So I think Rush Limbaugh reacted with a column that said, "Well, we're really talking about Democrats in waiting." So I don't know. I mean, it's kind of funny how these phrases. I'm not sure anyone used the term Americans in waiting before. It wasn't that I made it up. Actually, when my publisher agreed to publish the book, they called me up and they said, we'd really like to publish this book, but we have a title for you. And I said, what's the title? And they said, Americans in Waiting. I said, yeah, that's a good title. Okay, so I won't claim credit for it, but now it's made the White House. And actually, it's kind of gotten into, in some ways, the political discussion. So, okay, so now I'm going to go explain, and some at this point, honestly, I'm not sure how many of you have looked at the intro and some have not, so I'll go through this somewhat more quickly than if I hadn't made it available, but not so quickly that it wouldn't be understandable if you hadn't. I think there are three issues that I think that have dominated political discourse over the last generation, and on unauthorized migration. And by the way, I use the term unauthorized migration because I'm trying to start with a neutral terminological point, as opposed to using the terms undocumented immigrants or illegal aliens. So one question is, what it really means to be in the country illegally. The other question is, what's the role of states and cities? That tends to be another thing that there's a lot of controversy about. Another is, are unauthorized migrants Americans in waiting? Now, let me just, where this comes from is that in the case of Plyler versus Doe, much of the book is built around the case of Plyler versus Doe. Well, it's not built around it throughout, but it is organized around this particular case. And as you know, that's the case in 1982, where the Supreme Court holds 5-4 that undocumented, unauthorized kids who are in the country illegally cannot be kept by the state of Texas from going to public school K through 12. And so Justice Brennan writes in 5-4 opinion that the state of Texas cannot bar these kids or exact or demand a prohibitively high tuition or any tuition. And so when Justice Brennan does that, he really has three parts of the opinion. And one part is to talk about, well, they may be in the country illegally, but they're not going to be deported. Not only that, but they're here as a function of an economic system that seems to rely on their labor. The second thing he says is that Texas has no legitimate interest in speaking to this issue as a matter of immigration policy. And the third thing that Justice Brennan talks about is, well, these kids are going to stay in this country, or many of them will, and we cannot have a underclass of people who have been denied a public education. And that's when he talks about Brown versus Board of Education as saying that education is the foundation of good citizenship. So I'm not using Plyler as a case, as a legal precedent. I think in many respects, as a legal precedent, Plyler is a high watermark, but I'm using it as a window into debate and understanding that Chief Justice Berger, when he dissents, is contesting everything that Brennan says on these three issues. And I was really struck. In the origin of this book, actually, the origin of the book is a talk I gave on the 25th anniversary of Plyler. And it was just intended to be about that. And then I realized, this is really interesting. Everything that's been in the news for the last 30 years has been about these issues in one way or another. And so this explains the first three chapters of the book. And then the next three chapters deal with and what I just laid out is actually in the introduction that we have. But then I should explain some of the chapters that I didn't distribute, because it gives you a feel for exactly how this book is put together. So state and local issues, there's a lot of controversy. There is a lot of controversy now, but I think especially in the year 2012, it was striking that the state of Arizona was getting involved directly in immigration enforcement through SB 1070, and the question is, what's the state and local role? And this is just, it almost seems obvious now in some ways, but this is just a way of articulating the state and local role. It's very hard to come to a judgment about what the state and local role should be, for example, in Arizona, without coming to a view about what it means to be present in the country unlawfully. I think if you think of unlawful presence as quite clear-cut and something that is determinative in the way that Chief Justice Berger did in Plyler versus Doe, then I think it only makes sense to expand the number of people who are allowed to enforce. But if you think of unlawful presence as very ambiguous and contingent on a lot of other things and subject to enforcement discretion, then you may want to cut back on the number of people who are allowed to enforce immigration law. So this is what Chapter 4 is about. It's really about Arizona and similar enforcement involvement of state courts, of states, state and local governments in general. But the state and local role is not just to enforce. The state and local role is also to be the place where communities, where unauthorized migrants can be integrated into communities or not. And so Chapter 5 is really about the flip side of the state and local role. Just as Arizona has been involved in enforcement in various ways, and other states and some localities throughout the country, other states and localities have taken measures to try to integrate people into their communities without regard to unlawful status. And so that would be an example of New Haven offering ID cards, or San Francisco offering ID cards, or many states offering in-state tuition and driver's license. And the next to last chapter is Chapter 6, which really talks about it's hard to come to a decision, one's own view about legalization, and whether legalization is consistent with the rule of law or an affront to the rule of law, without coming to the view of how you see the undocumented. As do you see them as Brennan did, or do you see them as illegal aliens? And it's also hard without coming to some view about whether claims of justice that might be advanced by people who are in the country without lawful status, whether those claims are valid or not. And they tend to coalesce in one's view about legalization. As you can tell, part of the spirit of the book is I mean, I certainly have a lot of points I'm making in the book, a lot of arguments I make, but I think that even without reaching those arguments, much of the point of the book is to help people understand why they disagree with each other so much. In other words, this, I don't know if this may be a vain hope, but this is such a polarized issue that part of the spirit in which I write the book is to try to help people who vehemently disagree understand that they, for example, have a very different view of Chapter 1. And of course, this is the oft-heard phrase, what part of illegal don't you understand? I suppose Chapter 1 could be called, in fact, I actually toyed around with calling it the parts of illegal I'm not sure I understand. But too cute. But and then Chapter 7 is about finding answers. I didn't distribute that either. But Chapter 7 tries to look outside some of these debates. And the hardest part of the book for me to write was the part on temporary workers, which is in Chapter 7. I think temporary workers is an issue on which people who think they agree politically about immigration law tend to still disagree with each other. A lot of people agree on much of the rest of this and then conflict on temporary workers. But Chapter 7 also deals with issues like international economic development and domestic education policy. So let me just do one other thing and then and that is to say something about Chapter 1, and then see what questions or comments or discussion you want to have, because I mean, I could keep going, but I'd rather hear from you. Chapter 1, I think, in many respects, drives a lot of the book. And Chapter 1, which again, this is something that you have, so I don't want to repeat, but just a quick summary of Chapter 1 is that it tries to lay out it tries to answer the question, why do we have 11 million people in the country who are here illegally? And I trace this back to patterns of labor migration that really go back to well into the 19th century, well back into the 19th century, with a pattern of recruiting of Asian labor to do things like build the Transcontinental Railroad, followed by economic downturns that led to Asian exclusion. And then Chinese exclusion then led to recruitment of Japanese labor. The Japanese were effectively, practically excluded by the time you get to the 19-teens, and then more clearly in the 1920s. And you have a turn toward Mexican labor, which was interestingly treated differently from a regulatory purpose rather than being a sort of a hard formal exclusion. It tended to be managed through a recruitment. There were no numerical limitations on Latin American immigration until the 1960s and 70s. And a pattern arose where Mexican labor was welcomed as a disposable workforce, as people who could be depended on to go back and forth and not to settle. And so you have patterns of Mexican labor migration and reliance on the American economy on labor migration from Latin America emerging really through much of the 20th century. And at the same time as you have a no numerical cap on so-called permanent immigration, you also have the Bracero program operating from the 40s and 60s. In 1965, everything changes. The discriminatory, or the explicitly discriminatory system that had governed immigration to this country until 1965 gets dismantled. The Civil Rights Act of 64 passes, the Voting Rights Act of 65 passes, and the Immigration Act of 65 passes. The Immigration Act does away with the so-called national origin system that had kept quotas by country in an effort to preserve the ethnic balance of this country. And formal equality is imposed, but it means that a couple things happen to Mexican migration. One is that for the first time you have numerical limits, Another thing that happens is the Bracero program ends for other reasons that have to do with labor abuse. And the third thing that happens is that you have a series of categories brought into law that make it very difficult to come to this country based on jobs unless you have a college degree. So all of a sudden, but at the same time, all these patterns of migration, including economic reliance, kept going, and so you have a system really of selective admissions, very selective admissions, and then necessarily selective enforcement. Very difficult to deport more than a fraction of the people in the country illegally. And somehow we've had a series of enforcement measures that look good, but have not been very effective. And the economy seems to like it that way. So under these circumstances, I think Brandon was right in saying that this was a pattern of acquiescence, in effect, in unauthorized migration. And if you take that view, which I try to advance in chapter 1, then I think a lot of different things follow. That leads to my support for legalization. That leads to my skepticism of empowering a lot of state and local actors to exercise the discretion to act on someone's illegal status. So that's just an example of the kind of thing that shows up in every chapter. And there are many other arguments in here, but that's to give you a sense of the kind of ripple effect of one part of the book. It's one of the complexities of this. I once, someone asked me recently, so what actually do you cover in the book? What would you want to talk about? And so I actually made a list of topics covered in each of these chapters, and I realized that there's like 50 or 60 of them. And then when they said, so what can you talk about? I said, well, I really like the kind of the band you hired at a wedding. I just know this book has a lot of songs in it, and I'd be happy to talk about any of them. But what do you want to hear about? And so I've just given you a little flavor of it. But let me just stop, or at least pause, and see what reactions you have, and I'll get a feel for how familiar you are with what I said to Brian, and then we can take it from there. Yeah.
I've got a million questions, but we can
Okay.
talk later. But one of them is about, it's something you touch on in the book, and I was wondering if you could talk a little bit more about temporary protected status.
Yeah.
You've got a group of people here in the United States, obviously, who some may be unauthorized, some may have come on student visas or employment-based visas, and for whatever reason, the government has said, hey, we're not going to send these people back to their home countries because of an ongoing armed conflict or an environmental disaster or some
Right.
sort of extraordinary and temporary condition. It seems like you've had a group of people now who have been here, I'm thinking about Honduras in 2001 or El Salvador with environmental disasters, who have now been here for over a dozen years, and the temporary protected status keeps getting extended.
Right.
I look at your categories and I think, they're not technically undocumented. They have no formal legal status, but they do have some status, so I don't know that they're undocumented. I think the administration would say they're not Americans in waiting because once we lift the status, they're going to end up being deported. So what about individuals who have TPS? Where do they kind of fit in your discussion?
Well, they fit in different ways, and that's a great question in the sense that it probes really what this is about, which in a really helpful way. So this temporary status, it turns out there are many temporary statuses of various kinds, and I think that they end up becoming, in some sense, a political compromise. There's some people who would say, well, why don't we expand refugee status and allow them as formal refugees to come to the country permanently and get green cards and be on a path to citizenship. Others would not want to take them, and so this ends up being in this gray area. It turns out that there are many parts of immigration law that are like this. Many sorts of temporary statuses, formal gray area statuses. And so when I say that an unlawful presence is ambiguous, it can mean different things. It can mean someone is in the country illegally for sure, but it's not. But there are many mechanisms that would allow them to maybe stay, that are written into the law. It could mean that someone is qualified, but is in a waiting line. It could mean that someone is in this gray area status. So in that sense, I think a temporary protected status is something that is just one of many examples of this kind of thing. Of the ambiguity of unlawful presence. Another way it fits into the book is that Chapter 6 makes the argument that we can argue all we want about legalization, and so you can think of it as good, or think of it as bad, but one thing I think would be wrong is to say that legalization is really unusual. There are many gray area status, there are many aspects of American history that have allowed people who have come illegally to regularize through sometimes through a number of congressional acts. But we don't think of them that way because but Cuban Adjustment Act, Chinese Student Protection Act, Nicaraguan Central American Relief Act, and Chinese Confession Program. And this may be the most radical assertion along these lines, but I think in many respects refugee and asylum law is a legalization program. But we don't think of it that way because we think that their claims are so strong. But think of it that way. So it fits in that way. But and sorry, this is such a long answer, but it's kind of like it gets into a lot of this book. But it really makes you wonder something really fundamentally about the way we handle immigration, maybe in any country, maybe particularly this country, but we tend to think of immigration and picking people and controlling the flow as being something the legislators do in advance, and that we should have these categories, and we have some faith, at least nominally, in the power of Congress to decide who we should let in. One can imagine a different sort of system. In Europe, some European countries have much more. They just legalize people every once in a while. One can have a system that way, and I guess the question is, what's wrong with that, right? And maybe we don't know in advance who's going to really be contributing, not commit crimes, and have a job and have a good work history. It's easier maybe with PhDs, but maybe harder to do with bricklayers. And so maybe we should just legalize people at the end. But then some people think it's an affront to the rule of law. So it's a So the TPS thing raises this question of maybe it's meant to be that to work that way, but at the same time, of course, it gives credence to the notion that there's nothing more permanent than temporary workers or temporary protected status. I can keep going, but I just want to see what. Sorry, go ahead.
So this might be a little bit in the clouds, but I don't know anything about immigration law, so
it's okay. The more I know about it, the more I realize I don't know enough. I don't know it.
Okay. So I wanted to hear more about acquiescence, and
Yeah.
I was prompted partly by the thought that in your other book you looked at lawful immigration as contract,
Right.
which I teach contract. So I was thinking of unlawful immigration, concepts in contract that deal with acquiescence, like
Right.
promissory estoppel and reliance.
Right.
Is there anything there?
Yeah, and there's a lot there. And I should say, just looking back at Americans in Waiting, that I think that one of the consistent strand of criticism I got, which I think of as not like core criticism, but definitely something that bugged people, was the way I use contract. And it's always came from contracts professors.
Sorry.
No, it's okay. It's okay. It's okay. And I'm saying, there's actually a thing in the book about saying I'm not using the word contract the way contracts professors use it.
Yeah.
I'm just using it as an umbrella to talk about lay notions of reliance, expectations, and things of that nature.
It doesn't even have to be contract, right? Because
Yeah.
acquiescence, there are a
Right.
whole bunch of theories of equitable
Right.
remedies that rely
Right.
on theories of reliance or acquiescence,
Right.
like easements.
Right, exactly. So what's going on, and this may fill out what I just said about Chapter 1. It is something I get into in Chapter 1, but then fill out more fully as the book goes into other chapters, is that I'm looking at, one way to look at the immigration contract is that it's stated in the law, and that you're breaking the contract if you come here against the law. You're breaking the contract if you overstay your visa because you've broken the provision that says you're supposed to leave in 90 days. But the other way I look at contract is that if there has been this invitation that people to work, and that will generally look the other way, then but you have to take a chance that things might get such that we'll have to be shocked that you're here. Then that's a different way of looking at the contract. So I do think it relies on things. There's a short discussion, not in Chapter 1, I think, but I think it's probably in Chapter 6 about adverse possession.
Okay.
And I'm just wondering if that is something that resonates, yeah, things of that nature. So I'm really trying to look at the contract in a textured way like that. And but I'm not sure it's sort of like rises to the level of sophisticated academic understanding of the contract. I'm writing about, one of the complexities, I'm writing the book about law, but this is actually not a book written for specialists in a particular sense. I'm really trying to, does that?
Yeah, no, I mean, I was actually thinking even at the level of public discourse, I don't know if debates about immigration reveal, I would think, a compelling argument in favor of giving people something close to, or if not full legal status, is a reliance-like argument that you have invited many of my brethren in, and you didn't kick them out, and you gave them jobs, and you gave them homes, and you gave them a bunch of rights. And at some point, you have to say that that's effectively a promise upon which they relied to their detriment. And we have other concepts of law where we say you get stuff, even if it wasn't an official contract. We're willing to formalize that.
Yeah, and I think that's right. But I think here I'll acknowledge a tough part of my argument, though, and this is something that I try to acknowledge as being complicated, and acknowledge the complexity and the fact that one could argue on both sides. I'm not sure what it means to have de facto government policy. I mean, I actually go out on a limb and say, well, I think this is de facto government policy to tolerate a relationship between the economy and enforcement so that we have a lot of really good people here. I think it's a logical consequence. But I know people out there who say, well, you know, that's not really policy. You can't, and so I acknowledge that, you know, but then let me get to the response to that. The response to that is that, and they often say the reason it's not government policy is because if that were government policy, that argument would lead to the government's not being able to change their policy. And my response to that, which I kind of lay out in the book, I mean, the book, much of writing the book is kind of exercise in self-reflection and like, well, you could say this, but then I would say this, but then you could say this. Is that I think it's important to separate out equities that have arisen in the past, and be able to go forward with a heavier enforcement regime. Yeah, I think it's a separate sort of. Yeah, but you want to follow up on
I was just going to say, I think that de facto policy occurs in all walks of law and government policy. So I'm not sure that that's a legitimate pushback on what you're describing, right? I mean, you could even go so far as to describe federalism itself as a de facto policy if you want to look all the way down, right? So, yeah, I'm not sure that that's separating this out from anything else, right? To say that it's de facto policy.
But yeah, no, I take the position as de facto policy, but I do want to be sensitive to the criticism that just because it's de facto policy, it has been, I think, for much of the last 100 years, it doesn't mean that the policy can't change. I actually question whether the policy will change. But then the question is, what would it take, and people have asked me, what would it take to convince you the policy's really changed? And I think often what people cite in that is that the turn toward heavier enforcement in 1996. I'm not sure really that convinces me that things have really changed. It convinces me that people want to build a higher fence, but it doesn't convince me that the population is supposed to go small, or that we're willing to really crack down on employment. So.
How do you balance this idea that so many people have, which is that the administration is kind of going too far with things like deferred action for childhood arrivals, or DAPA, you know, this newer program with respect to executive action? How do you square that with the idea that some of the same people who are making these arguments about an executive that's too large and acting lawless was kind of behind the delegation of power from Congress to the executive branch, especially in the 80s and 90s? I mean, it seems like there's this enormous delegation of power, kind of in an administrative law sense, of power from the Congress to the executive branch. And nowadays, it seems like there's been this extraordinary backlash from the same individuals who were behind that delegation of power once that power is being exercised.
Yeah, no, that's also interestingly complicated, right? I mean, it's a couple comments, and then maybe follow up on this, and tell me if this is responsive or not. Is that one of the consequences of the system, which I guess I'm calling de facto policy or acquiescence, one of the consequences of that system is that the real locus of immigration law is enforcement, and the real locus of immigration enforcement is exercise of discretion. And the question really is who exercises that discretion. So that's comment number one. Comment number two is that I think a lot of the discourse on all sides about immigration and immigration enforcement is a contest over this phrase, rule of law. Because certainly John Boehner would argue that when President Obama undertakes to quasi-legalize, as he would put it, or maybe he would say legalize people by stroke of his own pen, that he's acting lawlessly and violating the rule of law. I think if you take the view that the locus of immigration law and immigration enforcement is in the statute, then I think you would tend to prefer the term illegal over undocumented, and that you would look at what the president is doing is antithetical to the rule of law. But I guess if you take the view that I do, that a lot of this is in discretion, then I actually think of DACA, the Deferred Action for Childhood Arrivals and Executive Actions, as actually promoting the rule of law, but in the following way. There was a series of memos issued by DHS for a number of years, really going back to the Clinton administration, but consistently, and then especially up through 2011, about discretionary, about prosecutorial discretion guidelines. Some people are high priorities for deportation, some are low priorities. The high priorities, of course, would be national security threats and people with criminal convictions. And low priority would be the kids who were brought to this country as children. And so what actually happened was that the rank and file of the immigration enforcement, immigration customs enforcement, rose up against the directives. There was a period when they wouldn't let agents go to training sessions, and there were a lot of inconsistencies in application. And so I actually think of this as not a question of I think of this as the system is really running on discretion. It's not a question of whether discretion is going to be central. It's a question of who exercises it. Is it going to be ICE officers, or is it going to be controlled? So that's how I think that this plays in. But I'm not sure if that totally answers your question.
I wonder if you could. I mean, I think there are a lot of people who might say that it ultimately ends up being controlled by Congress in a sense. But what's so amazing is that Congress, I mean, especially after 9/11, gave so much power, especially in reorganizing everything to Homeland Security. I mean, it's just amazing. Gave up so much power, delegated so much power to the executive branch, and now it seems like. And then they also, coupled with that delegation of power, chose not to fund the agencies sufficiently. And once the power is being executed and exercised in a thoughtful way, arguably, there's a lot of complaints about that. It just doesn't seem to square with policy 10 years ago.
Well, I mean, I agree with you, and I guess the source of my agreement, and maybe this is where you're coming from as well, is that this is the system that Congress built, basically, right? It built it by having an enforcement system directed against employers that is kind of designed to look good, but fundamentally be ineffective. That was the result of political compromises. And so this is kind of what, they got, right? But the other thing that this reminds me to say is that this, of course, has gotten so polarized in the last, not just the last generation, but I think especially in the last 5 or 6 years. And so, of course, it stands to reason that people would argue that this violates the rule of law. I think things are much worse in terms of Congress doing anything about this than they were in 2007, when one of the principal pieces of legislation on this topic was the Kennedy-McCain bill. And it's really it'll be very interesting to see how the Republican Party deals with immigration in the period, well, really from now through the 2016 presidential election, as the political context shifts from midterm elections to presidential election. I think that's really going to be quite, and there are people who say that DACA was crucial in getting Obama elected. We tend to forget how close the election looked in May of 2012. Yeah, go ahead.
It's my impression that the political polarization starts to break down when you get into certain areas geographically in the country. Is that still an accurate impression, or am I confused? It seems like that difference between Democrats and Republicans gets much more cloudy as you get closer to borders.
Yeah, by breakdown you mean that it explains less and it's less polarized?
Yes.
Yeah, it's as you get closer to like South Texas or something like that.
Yeah, Texas, or even kind of ports that you see in Florida, or I guess Queens. I think it probably starts to break down. You get it just doesn't mean as much anymore once you're in one of those geographical
Right.
locations.
Yeah, I mean, this gets into a lot of stuff that political scientists and maybe some of you know a lot better than I do. But I mean, some of this has to do with the number of safe seats in the House and the fact that there's enough that there are enough safe seats not falling into your description. But I think there are a number of areas where, if you look at possible legislative action in the year, I don't know, 2015, 16, 17, we're looking at some things where polarization does, that characterization breaks down. One example of this is Republican congressional districts in California that have heavy Latino populations, but have almost always, or for a long time, been Republican. I think you see this also in the state of Texas, where I think there's more of a sensitivity to demographic change, and where the George W. Bush, for example, was much more pro-legalization. In fact, he was meeting with Vicente Fox to talk about a legalization program for Mexicans on September 10th, 2001. I mean, that's literally how was going on the week of September 11th. So there's that. I think you tend to see that. Not so much in urban areas per se, but in suburban areas where you have, I got it, thank you. In suburban areas where you have more of a mixed partisan. But it's been interesting to see, you know, where Jeb Bush is going on this, and also the changes in Marco Rubio's position. Because, you know, Marco Rubio really, I think, has turned really more against amnesty. I mean, I think that, but it's interesting. I mean, there's an argument that Marco Rubio was ultimately responsible for DACA. And the reason is this, because the Dreamers really pushed the political movement that got the president to allow the deferred action. But the reason they were able to get in the door was because they were able to say, quite credibly, you know, if you don't talk to us, we got this guy Marco Rubio in Florida, and he's going to talk to us. And I think that they successfully outflanked the resistance in the White House, and then they got in the door. So I think that's going to get really complicated. Go ahead.
So this is just reminding me of a discussion that Jeb Bush had, I guess, maybe 2 years ago now, where he was, you know, presenting a very positive spin on immigration, particularly saying, well, we want immigrants in our country because of families. They have better
Right.
families than Americans have. We like that they're hard workers and that they stay together and that's unified. So I was wondering if you had any sense of how this sort of argument plays out and what are the kinds of repercussions. I mean, is this something we're going to continue seeing in terms of using families as a vehicle for which, I mean, you also talked about 1965, which was also marked, right, the difference between national quotas to allowing families to come in through family-based immigration. And so just wondering what kind of that relationship is.
Yeah, I mean, part of what you're asking is a question about sort of the politics of different levels of term, different definitions of term politics here. You know, I think that there is a sense, part of this is a sense that many immigrants are really kind of classic family values types, you know, and this is kind of this, in some sense, this wistful notion that the Republican Party hasn't handled immigrants. The immigration issue very well to its long-term detriment, because so many Latino immigrants are potential hardcore, not hardcore, but you know, I mean, sort of core, I should say, Republican constituency. And I think there's kind of a lamentation of that particular turn. I mean, this goes back also to Proposition 187 in California in 1994, which I think really drove a wedge between the growing immigrant population and the Republican Party, and this is the reason why it's very much become such a Republican and such a Democratic state that when Governor Schwarzenegger, a couple of years, I think when he gave his last State of the State address, that as a Republican, of course, the Democrats responded, but also the Republicans responded with a rebuttal. So. That's one thing, but the other thing, which you may be getting at, but maybe I just want to throw out in discussion and see if this is part of what you're getting at, is that I think there's this part of the difficulty of immigration policy. I have to admit is the difficulty of sort of saying that, there's some immigrants that are better than us, or some of us, and that we're going to prefer them and kind of leave people who are already here at disadvantage kind of in the dust, and so I'm kind of afraid of that too, and so part of what I try to address in Chapter 7 is my concern for that as well, because I do think that even if there's a net macroeconomic gain, which I think most economists agree there is, I think there are displacements both for particular populations, but also that there's the tendency to collect money at the federal level and not to distribute it or make it available at some local levels, and I'm concerned with that too.
And the flip side to that too is that you actually don't need to be an intact family to come into the United States, right? The idea is that immigration law actually allows, even if you're here on like a spousal-based visa, you can divorce, you can do a lot of things once you have status. So it's also sort of even incorrect in a way if we're talking about just legal status, if we're not talking about the reality of these potentially like, core families who stay together. There's also the reality that you actually can be in a different types of family relationships, even.
Well, the other thing is kind of interesting that the American system, if you look at who gets let into the country lawfully on and just look at the numbers, it's really amazing. Maybe I shouldn't use the word amazing. It's just interesting, at least, that so many people are allowed into this country lawfully on the basis of family. It's either, it's well over 60%. You could make the argument it's well over 70% because many of the people who come in nominally in the employment categories are actually the family members of the people being employed. So that's one thing. But another thing is that it's very difficult, as I said, to come into the country without a college degree if you're coming in based on a job. So it's part of this interesting notion. There's a kind of interesting contrast between the valorization of certain things and maybe what we ought to do for the economy. So an example of that is, I think we like the idea. No one seems to be, I shouldn't say no one, but it's a politically an easier sell to say we need more PhDs, we need more highly skilled people. Maybe that's true, but I'm not sure the argument is. But I think there seems to be a great need for people who don't have college degrees, but that doesn't sell particularly well. And another thing that's interesting is that we often think about families and employment as if they're different, but it turns out, of course, that most people come by family. They do work, right? And the other interesting thing is to look at the economic impact, because I just recently read a paper that said basically, you're looking at the wrong unit of measurement if you're looking at the economic impact of families, because what's really going on in a lot of immigrant families is the grandparents are doing the child care, and that allows the parents to run a bodega that's open 8 hours a day. And so it's also another thing, and this is also another dilemma of immigration policy, is how much you look at this generationally. I think that's implicated here in your question as well, because I think a lot of the difficulty with immigration policy has to do with the fact that we don't really look a generation ahead, and that's, as much as I favor legalization, I think it's a good idea and maybe an inevitability or a necessity in the short term. Chapter 6 talks about being cautious about politically pushing entirely for legalization, because if that's all we get, then we'll have the same conversation in 30 years. That's really the problem.
Yeah, I wonder, in terms of finding answers in your book, which I sadly haven't had a chance to read yet, whether it matters why we seem to have adopted a national policy of tolerating immigration outside the law, because in the abstract it doesn't seem like that would be the kind of the policy ex ante that we would choose, but nonetheless that seems to be the political kind of where we've ended up and stayed for quite some time.
Yeah, so let me say this, but I have a feeling I'm not totally or going to answer the first part of your question or the premise. So I think that in many respects the policy works for a lot of people in this country. I think it's very hard to predict who will be contributing. I think in advance. I think that what we have is a system where periodically we discuss broad-scale legalization. We have smaller-scale legalizations. we have many legalizations and micro legalizations all the time when we allow people to state tuition or give people driver's licenses. And I think the most cynical part of me thinks that it works to have a group of people that you can treat in this sort of like very flexible way. I mean, that's been the history of this. So in that sense, maybe it is a policy that it's not a policy you would pick ex ante in a formal way, but it's kind of like, it's kind of a funny way to put it, but it seems like in retrospect it's a good ex ante policy, basically. But I'm not sure that tied in the first part of your question. You phrased it in a way that I wasn't quite sure where you were going with the inquiry into whether it works.
Right. I mean, I guess I was asking the question in the sense of probing what kind of answers you're looking for, and whether you need to think about the implicit or explicit policy rationale behind the policy you've adopted in order to answer the question how we ought to think about immigration inside and outside the law in relationship to national and local and state policy. You know, and I'm inclined to take the kind of public choice story you've suggested at the end of your previous comment there as at least a big part of the puzzle. But I obviously think there's a lot more going on there as well.
Yeah, no, I'm glad you followed up on that, because I have to admit that much of writing this book and really trying to get my brain around this whole thing. I mean, this book took me 8 years to write, or 7 years, something like that. I actually calculated that I spent 9 hours a week on it for 7.5 years. I mean, not every week. I literally spent about 3,500 hours writing this book over that period of time. I think that much of this kind of exercise fundamentally reflects things that we take as realistic, as sort of inevitably realistic and too hard to assume away, and things we're willing to assume are somewhat changeable. So, if I give you an example, someone I know at Boston College wrote a review, which is basically, I guess you have to say it's a negative review of the book, but it's a very highly praising negative review of the book. You know, I mean, basically says this is the most thoughtful and honestly argued but flawed book on the subject you're likely to find. But I don't know how to take that. But his criticism is that I take employer power too seriously. You know, I sort of take it. I say this is de facto policy. Employers have this policy, and he takes me to task for taking employer power, or for that matter, capitalism, I suppose, as a given. I suppose. But then he says that my concern for disadvantaged populations and localities in this country is misplaced, because he says that I pretend to be concerned, but I don't accept the fact that those people always lose. So in a way, it's a question of So I'm taking I'm sort of regarding as a site of some optimism that it's possible to have some type of tax on employers that will allow them to get the employers they need, but then transfer some of that money to people who are disadvantaged. I'm more confident about that than I am about not having globalization outsourcing employer power. So I don't know. And a friend of mine told me, this is a 7-chapter book, right? He says to me, I really like chapters 1 through 5. And the reason he says, because chapters 1 through 5 you lay out what you're thinking. But 6 and 7 you really talk about political compromise and what's really realistic. It turns out, actually, what's realistic runs through the whole book, because I think chapter 1 is very much driven by this is what the economy seems to need, and if employers don't get it, they're going to send them move their factory someplace else, and then this over. So I do think that your question really about sort of where you look and that's really important. I mean, it really gets to sort of what one does, I suppose, when one writes about these issues, but any issues, right? Go ahead.
Can you fill in the blank a little bit? 'Cause I'm not sure what your position is on what the state and local role is or ought to be, and I feel like I'm missing that in what you're
Okay.
saying right now.
Okay.
Yeah, thank you.
Okay, this is a part, I'm glad you asked this because this is also a part that I think could end up generating some controversy either here or more generally. My concern with the state and local role is the over-delegation of power to people who may discriminate in a way that is impossible to detect or remedy.
Mm-hmm.
And that follows from my view of the system, right? And so if it were very clear that we apprehend and get rid of people who are in the country illegally, if that were the historical practice, I think it would make sense to empower more people to exercise that function. But to the extent that this is highly discretionary and you're talking about people who have some record of acting inappropriately on the basis of racial and ethnic profiling, I'm concerned about that. So I think of federalism here as a prophylactic federalism, a federalism that in some sense is like Miranda warnings or other things that we do because or void for vagueness principles, where we have laws that are intended to prevent things from happening that might be bad and we're never sure what they are. So I have a view of federalism that's very influenced by some lack of faith in equal protection principles to detect and remedy things that may be inappropriate. But I'm also, so the question really is, it's not to see federalism as a matter of turf, but rather as a matter of function, in particular prophylactic function. And so I come out actually thinking that if there is no potentially discriminated against person, then I'm much less concerned about a state and local role. And this is why I come out in Chapter 5, much more in favor of allowing state and local governments, where in fact integration has to take place, to exercise judgment on driver's licenses and in-state tuition. Now, I mean, that's, some people say, well, that may be a convenient, outcome. But I actually think it's coherent conceptually because when, in all the federal court cases that have attacked in-state tuition, and the ground is that, oh, my tuition's higher because you're letting the illegal aliens get in-state tuition. All those cases have been thrown out for lack of standing. So that's an interesting insight into that particular problem. But I also admit that one would not take this view if one weren't somewhat sympathetic, or if one didn't have this view of Chapter 1 that I do. But I think some of the mistake here has been to look at immigration policy as a turf question, because I think it's actually very hard to discern what is immigration control directly in terms of border control and what is immigration control indirectly through housing and through employment restriction systems.
Don't you think the turf question comes from the way the Supreme Court treats these questions in the first place?
Yeah.
I mean, they do treat federalism like a turf war, rather than a question of
Right.
who ought to govern in what circumstances,
Right.
i.e. for the good of the people, right? So it is often treated, I think, by the Supreme Court like a turf war, right? You think about cases like Hines versus Davidowitz, right?
Yes.
Field preemption and
Yes.
Article 1, and right, this is Congress's job, and
Even
so,
the term field preemption, right?
Yeah, right. I mean, so I guess it's not surprising to me that that's
Yeah.
how it gets treated. And I appreciate the nuance that you're bringing to that. But I do wonder, where is there room for the states and localities, given that Congress treats this as its alone, right?
Yeah, I mean, I think that that involvement in enforcement directly and indirectly by state and local government goes beyond the boundary I would set, mainly because of the prophylactic aspect. I'm not saying that federal government doesn't discriminate. I think it can. I think it certainly does. But it is much harder to push back against 18,000 local law enforcement agencies as compared to Department of Homeland Security. And so that is, that's a major reason. But I appreciate what you're saying about the Supreme Court and the way it's looking at this, because I think that here's the problem is that I feel like in terms of mainstream, maybe mainstream's not the right word, but in terms of people who would self-identify as federalism scholars, the way I'm looking at this seems almost strange or sort of at least different. And it really raises this question, sort of a deeper question, which is whether I'm suggesting there's something wrong with federalism doctrine in general, or whether there's something different about immigration. And I've spent a lot of my time as a scholar arguing against the marginalization of immigration law. But I have to admit, and I do confront this in the book to some extent, I do admit that part of this argument starts to look like we ought to treat immigration differently all of a sudden. And I think the way the way I've come to think about that is that I think we ought to treat it the same way, but understand that within the same analytical framework, it might be different in the same way that all things are somewhat different. And so, for example, in the plenary power doctrine, which is part of the bedrock of constitutional immigration law, in that context, it's often said that there is no judicial role to hear constitutional cases. I'm very troubled by that, but I'm not troubled by a judicial role that says that the Constitution might apply differently in a national security case, or the Constitution might apply more weakly to someone who's never lived here and has no connections here. I'm okay with that. And I think about Justice Kennedy's decision. I think it was Kennedy in the Wynne versus INS case. It's a case about gender discrimination in citizenship law. I actually like the way he applied all the mainstream gender discrimination precedents, but said that they apply somewhat differently in the immigration context than they do domestically because it's an immigration context. That was much more okay with me than saying, well, we have no judicial role because it's an immigration case. He took it seriously, and whether or not I agree with the decision, because I mean, in a way, I would have come out differently, but I respected the way he did that, which I think was really more like saying immigration's only slightly different, but it may have something to tell federalism generally.
Yeah.
Yeah.
I want to thank Hiroshi.
Okay, well, thank you for listening. Thank you. I want to hear your other million minus 2.